Good morning, students. Welcome to Ekcel Academy's CSEET crash course. Today we'll be continuing legal aptitude from where we left yesterday. Before we proceed further, let me just remind you that right now Ekcel Academy is conducting the CSEET crash course for, of course, CSEET itself for the upcoming exams basically. So the classes are held for all the subjects of the CSEET course, that is all the 4 subjects. Even if you're not taking up CSEET or if you're already in executive or professional, I would still suggest keep an eye out for logical reasoning and English or communication, because this is something which will be useful even though you have passed CSEET. If sometimes what happens, students directly take up executive program. So for them, these 2 subjects would not be covered in any of the executive subjects. So that's why I would suggest just attend the classes. Anyway, it's free of cost. Or even if you do not wish to attend the live class, what you can do is just visit ekcelacademy.com, EKCELACADEMY. The link is there in the description. And register there for free of cost, and then maybe you can take the benefit of all the lessons which are already recorded. So there are, of course, for the CSEET students, we have notes so that they can refer to it instead of the reference material if at all you think it is too much. Then we have quizzes, that is MCQs, then mock tests as well. So you can take it up and be prepared for the exam. You don't have to wonder what exactly is in store when you actually appear for the exam. So now only if you take up enough number of mock tests, that will give you huge confidence boost to actually write the main exam. So please do take it up seriously. Anyway, you don't have to pay for this. So I hope you take the benefit of this. Now that the announcement is done, let's directly move to the subject. I think we were in consideration. We had started consideration but not yet completed it. Let me just scroll to that part. Yes. So we had come up to this point wherein we had covered the basics of consideration. That's it. Wherein, let me just go through the definition once again for the benefit of those who are joining us today. Now, if you look at this, the definition says, when at the desire of the promiser, the promisee or any other person, it could be any other person, need not be the promisee himself or herself, has done, past tense, or abstain from doing, or does or abstains, present, and finally they say or promises to do or abstain from doing something in future. Such an act or abstinence or promise is called consideration. That's what they say. So okay. So now what we have to understand here is consideration need not be present only. It could be past also, or it could be future as well, depending on the contract. Now let us look at the other principles involving consideration. So again, they have explained the same thing. Consideration is at the desire of the promiser. Now there is an example which is very valid. If you understand that example, you will understand why it should move at the desire of the promiser. Otherwise, we cannot say that it is valid consideration. For example, A rushes to B's help, whose house is on fire. Let's say A and B are neighbors and B's house is on fire, and A voluntarily, without being prompted, without being requested by B, rushes to help B. Now, can A later on say that he has to be paid compensation for helping B voluntarily? Of course not, because if at all there is a contract, there should be consideration at the request of the promiser. So here the promiser is B. Did he request anything? Did he say, you please come and help me douse the fire? Of course he didn't say that. So therefore this did not happen at the request of B, and hence there is no consideration here from the point of view of A. So therefore he cannot claim compensation. Okay, we have Varun here. Hi Varun, good morning. Next, consideration may move from the promisee or any other person. So this is interesting. Here we differ from English law, wherein there they say consideration must move from promisee, whereas in Indian law, even a stranger to the stranger to the contract, even though he's not fully stranger to the consideration, cannot sue on a contract. So this is in English law, but in Indian case, what happens is it need not move only from the promisee. For example, we'll take this very famous case law, Chinnaya versus Ramaya. So this, by the way, happened in 1882, more than a century old case, but still very much relevant. Let's see what exactly happened. A lady, by deed of gift, made over a certain property to her daughter. So what do we learn up to this point? There was one woman who gifted some property through a deed to her daughter. Now further, what she has done is she has also directed her daughter to pay an annuity, sum of money annually, to the donor's brother. That means basically her uncle. The daughter has to pay her uncle some annuity, because donor's brother in this case would be, the donor is the mother and mother's brother would be your uncle. So now what do they say? Okay, pay an annuity to the donor's brother as had been done by the donor herself before she gifted the property. What the mother used to do was she herself used to donate some amount every year in the form of annuity before she gifted the property to her daughter. But now that the property is in the hands of daughter, she's also asking the daughter to continue the same. On the same day, her daughter executed in writing in favor of the donor's brother, that is her uncle, agreeing to pay the annuity. So she also drew a contract saying, I will do this. Afterwards, after some time, the donee, that is the daughter, declined to fulfill her promise to pay her uncle. Now this is where the problem arises. Now, until some time she used to donate, but after that she said, why should I do this? He is not paying me anything. I am not getting anything from him in return for the amount which I am paying my uncle as annuity. Why should consideration move only from my side? Why is there no consideration from his side? Since consideration should be there in every contract from both the parties mutually. In this case, there is no consideration from him to me. So therefore, I request the courts to declare this contract null and void. That's exactly what she pleaded. But the problem here is, in case of Indian laws, the consideration need not move from promisee. It could move from anyone else. Now in this case, if you consider her mother as promisee, the donee, who is that donee's brother, donee's uncle as the promisee, because he is the one who is receiving the benefit, it need not move from promisee here. The consideration hasn't, of course, moved from promisee because he is not giving anything in return, but the consideration has actually moved from his sister. So does the law prohibit consideration to be moved from someone else? Or like for instance, A does something to B, but B need not do something to A in return. Maybe he will ask C to do that. So in such a case, A cannot say consideration has not flown from B. It need not. It can flow from other party as well. So that is the beauty of consideration, wherein they say consideration may move from promisee or any other person. Just remember this case law. You'll be able to understand what exactly is happening. Anyway, let's move on. Next, privity of contract. So this is a very important principle, wherein they say a stranger to a contract cannot sue if you are not part of the contract. If the contract does not involve you as one of the parties, then there is no way you can sue. Of course, this is applicable both in Indian as well as English law. So of course, there are a few examples. I mean, there are many examples. So you can have a look at this. I'll actually look at this example, which I think is better. A person who is not a party to a contract cannot sue upon it, even though the contract is for his benefit. What they're trying to say is, there may be contract between two parties, A and B, and you may be C. Now, one of the terms of the contract is that A will do something or B will do something for your benefit, that is your C's benefit. Now, let's say they don't do that, or one of the parties to the contract fails to do that. Can C, who is a beneficiary but not part of the contract, sue the parties saying that you did not fulfill the terms of the contract? Unfortunately for C, he cannot. because what is he to the contract? He is a stranger to the contract. If it is a stranger to the contract, then there is no way they can sue upon the contract. So that's the thing. Now let us look at consideration or different types of consideration. We have already seen this, so I'll just skip this. There is executory, future, executed, present, past. We have already seen that also. It could be either in present, future, or past. Let us look at few of the rules governing consideration. So we have already seen many of this, but it might be a quick recap. Every simple contract it is anyway, must be supported by valuable consideration, otherwise it is formally void. That's what they say. Formally void means it will no longer be a proper contract. To some exceptions, this is important, we'll come to that later. That is, without consideration also, there are some contracts which are considered valid. We'll look into those later. Consideration may be an act or abstinence or promise. So what they're trying to say is, you may promise to do something or you may promise not to do something. In both the cases, we will consider that as consideration. There must be mutuality. This is very important. This is what we discussed in Chinaya versus Ramaya. Each party must do or agree to do something. That is what they say. A gratuitous promise, as in the case of subscription for charity, is not enforceable. Gratuitous promise means someone who is doing something on their own, like donation or etc. So in such cases, we cannot say consideration must move from both the parties. We'll come to that when we look at exceptions. Consideration must be real and not vague. Of course, this applies to the terms of the contract as well. Everything should be real and not vague. Even offer should be real and not vague. The terms of which should be clear. We have seen that yesterday. It cannot be indefinite. It cannot be illusory. That means you cannot simply promise the moon to someone. So now there is an example here. A son's promise to stop being nuisance to his father being vague is no consideration. Again, is there any clarity in the words stop being a nuisance? Of course not. Everyone can interpret that particular phrase in their own way. So therefore, since it is vague, it cannot be considered as consideration. Although this is the most important point here. Although consideration must have some value, it need not be adequate. That means A might sell land worth rupees, let's say 20 crores. B might pay him only 20 lakhs. Later on, A cannot say there was no consideration because there was some consideration. Was it adequate? Definitely not. But the laws say that without adequate consideration, contract is valid or void. Of course not. Law doesn't require the consideration to be adequate. It only requires the consideration to be present. That's it. As long as the consideration is present, then it is fine. Doesn't really matter whether it is adequate or inadequate. Consideration must be lawful. Okay, this we have already seen. And the other important point here is consideration must be something more than the promisee is already bound to do for promiser. If I have to give an example, let's say you go to RTO where you get the driving license and you meet the officer there, and the officer looks at your driving skill and maybe they are impressed, but they say no, you are bound to pay me extra money. Until you make the payment, I am not going to issue driving license to you. Now in this case, the person cannot say consideration is not moving from the person who is getting the driving license, because they are already duty bound to the promiser to issue the driving license, because that is part of their duty. They cannot say they need extra consideration. So that is something which you have to keep in mind. If you are already bound to do that, then you cannot claim that as consideration flowing from your side. Okay, one of the most important aspects, the exceptions to the principle, no consideration, no contract. Generally, that is the principle. If there is no consideration, then there is no contract. But there are few exceptions, important ones. Let's see. If it is expressed in writing and registered, if it is expressed in writing and it should be registered, and is made out of natural love and affection between the parties standing in a near relation to each other. See how many conditions are there here for the exceptions. So first of all, it should be in writing, it should be registered, it should be made out of natural love and affection, and it should be between parties standing in near relation. So the best example would be father and daughter, let's say. So what did the father do? He probably bequeathed his property to his daughter. But how did he do that? In writing. Did he get it registered? Yes. Is it made out of natural law? Yes. Is it between parties standing in near relation? Yes. Now we can say, of course, this comes under the exception, because now daughter need not do anything, because father has already bequeathed the property. Can someone say no, because daughter is not giving anything in return, this is not a valid contract? Of course not, because this comes under the exceptions, but there are a few conditions here. Next, if it is made to compensate a person who has already done something voluntarily for the promisor, or done something which the promisor was legally compellable to do. Okay, this again I'll have to take that fire example. So A's house is on fire, B rushes to help A. B did that voluntarily. He did not expect A to pay anything. But once the fire was doused, A made a promise saying, I will pay you 50,000 since you doused the fire. Without you, I would have lost properties worth rupees 50 lakhs. Now A made this promise, let's say a week after the incident, because he had to recover from the shock, etc. etc. Now B can enforce this because it is made to compensate a person who has already done something voluntarily. Who has done something voluntarily here? Of course, B. Now, who said that he will make the payment? Did B ask for the payment? Of course not. A himself said this. So, in such a circumstance, A later on cannot say, only I am paying 50,000, B is not paying anything to me. No, of course not. He has already done that service. Okay. So, that is also an exception. If it is a promise in writing and signed with a person to be charged therewith or by his agent to pay a debt barred by the limitation of law. This is interesting because law bars debt, or rather law of limitation bars debt after 7 years. After that we cannot collect debt from the debtor. But even after the expiry of that period, let's say the person who owes you money, let's say A owes money to B. Already 7 years has lapsed, 7-year period. Now A voluntarily promises to be saying, I owed to you some amount, but now it is barred by limitation of law of limitation, but still I'll make sure that it will be paid along with interest. So now A has promised. Later on A cannot say, it is anyway barred by debt. Why should I make the payment? I am making the payment. B is not paying anything to me. Of course not. But in this case, there is specific provision making it an exception to the principle, no consideration, no contract. But if you strictly look at this, B has already lent the money. Maybe long time ago, but still he has lent the money. So that is also a consideration. Anyway, it is under exceptions. We are just looking at it. Next point. Besides, according to section 185 of the Indian Contract Act, consideration is not required to create an agency. This is very interesting. If you want to create a relationship of principal and agent, wherein one person is the principal, he sends his goods, for instance, to agent so that he can sell in his shop or place. If that is the case, then such a contract, that is contract of agency between, let's say, A and B, doesn't require consideration. Of course, doesn't mean that money doesn't exchange hands here, but consideration rule says consideration is not must and should when it comes to contracts of agency. Next, in the case of gift actually made, no consideration is necessary. There need not be nearness of relation, and even if it is, there need not be natural love and affection between them. What they're trying to say is, A gifts B, let's say, on the occasion of his marriage. B's marriage, of course. Okay. Now, it is a completed gift. A is already gifted. A is his friend. There is no natural, there might be natural love and affection, but still, there is no relationship between A and B. And A cannot now claim that I have paid you something. Now you pay me in return. No. If it is a gift, then there is no question of consideration. You cannot say he has to return the gift as well. So that is the thing. Completed gifts doesn't require any consideration. Now there are few things which we have to consider wherein a contract is no longer a contract, or an agreement cannot be considered as a contract in certain cases. Which are those? Let's see. Agreement may be treated as if no effect and it will be known as void agreement. Okay, so we will look at the circumstances directly. Why simply waste time there? So I'm directly coming to the specific points here. Void agreement is one which is destitute of all legal effects. Basically, something which no longer has the legal effects, or which never had the legal effects. Legal effects means all the section 10 elements. We have already seen section 10 yesterday. Section 10 is one of the important sections in Contract Act, which talks about the essential elements of a valid contract. If those elements are not there, then what do we say? It's not a contract. But here we have this word agreement, void agreement. Why do they use void agreement and not void contract? Of course, sometimes they use the word void contract as well, but void agreement essentially means at the agreement stage itself, it is not a valid contract, because one of the elements of section 10 is completely missing, and therefore you cannot consider that as a contract itself. Because if you say void contract, contract is what? Contract is something which is legally enforceable. Then if it is legally enforceable, how can it be void? So therefore we use the term void agreement itself. Let's see what exactly they say. According to section 2J of Indian Contract Act, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Very simple definition, but can be confusing. Let's say A and B have entered into an agreement wherein A tells B, I will sell lottery tickets, so that he is a dealer of lottery tickets and is a shopkeeper, or let's say trader of lottery tickets. Now A and B enter into a contract wherein they are supposed to exchange lottery tickets, and B is supposed to pay the money. But so far so good. They were carrying on this contract since some time, but one fine day the government of the state, whichever state they are in, banned lotteries or sale of lottery. If that is the case, whatever contract they had now ceases to be enforceable. That's it. So it is no longer a valid contract, and hence it becomes void contract. A contract which ceases to be enforceable. Ceases to be enforceable means it will be no longer enforceable. Until now it was enforceable because it was a valid contract. A used to sell lottery tickets and B used to buy them and sell in his shop. But now, all of a sudden, the government of that particular state banned the sale of lottery tickets. Now, it will no longer be enforceable. It will now be considered as null and void. Next. An agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of other or others, is avoidable contract. This is very interesting. Here, only one of the parties to the contract can either not enforce the terms of the contract or enforce the terms of the contract. Basically, one will have more power over the contract. Let's say A and B, they have entered into some contract. A had actually threatened B to enter into a contract. If you don't enter into this contract, I will maybe cause you physical harm. That is what A had told B. Under such a threat, B feared for his life and health, and therefore he entered into some contract. Let's say contract of real estate. Maybe he wants to construct or build or sell, buy, whatever. Now B can actually make this contract void because he is the aggrieved party. He is the person who has suffered some loss. Since he has suffered from some loss, he has the power to make this contract voidable. Voidable, valid contract from the face of it, but since there is one party who was threatened, he has the right to make it void. So that's why it's called voidable. Can A do the same thing? Can A say, I threatened B, so therefore let's not carry on this contract? No. Only the aggrieved party, that is B, has the right to make the contract voidable. Next. Again, the same thing has been explained. Now let's move on to illegal agreement. Illegal agreement is one which, like the void agreement, has no legal effects. Okay. Further, transactions collateral to it also become tainted with illegality and are therefore not enforceable. That means, let's say if you have an agreement, if A and B have an agreement wherein there are 1, 2, 3 points, and one of the points is illegal in the agreement. Now they cannot say we will carry out points number 1 and 3 because they are still legal. No. What does the law say? If one of the points of the agreement or if one of the provisions of the agreement is illegal, then the whole contract also will be considered as illegal. That's why they say it also become tainted and illegality and are therefore not enforceable. So that is something interesting. Next, parties to an unlawful agreement cannot get any help from court of law, for no polluted hands shall touch the pure fountain of justice. They've used colorful language, but what they're trying to say is, if you have an agreement to smuggle, let's say A and B, A has, of course no smuggler will have an agreement, but still let's, for the heck of it, imagine so. A tells B, or rather he has a contract wherein it is written that I will smuggle the goods for you, you make the payment to me. So far so good. A used to smuggle the goods and B used to make the payment. But one fine day they quarrel for some reason and now they want to visit the court of justice. Now, according to the law, they're saying polluted hands. Polluted in the sense, not literal sense, but what they're trying to say is you are a person who's indulging in the activities of smuggling. So we do not want to deal with you. So who is saying that? Pure fountain of justice. So therefore, polluted hands shall not touch pure fountain of justice. If you have an unlawful agreement, deal with the other party on your own. Don't come to the court. Basically, that is what they're trying to say. Okay, so now they say chief flaws. These are not flaws. If these are there in the contract, then it will not be considered as a contract. Okay, we'll see what exactly. Actually, these comes under competency. Concept of competency, wherein we say the parties to the contract are competent. When all these things are satisfied. Let's see. Actually, I was referring to this. Actually, this comes under free consent. Okay. Free consent concept, competency is this capacity. Anyway, let's see what exactly we have in store. When do we say that the parties to the contract are competent? When they are not minors, when they are not lunatics or people of insane mind, and they are not persons disqualified from contracting by any law. That means a minor, that is someone who is aged below 18, cannot enter into a contract. A lunatic, person whose mind is not sane, cannot enter into a contract, and also those expressly disqualified. That means court, one or the other court would have disqualified them, saying you cannot enter into a contract, you are being disqualified from entering into a contract. So if that is the case, then those people are not competent to enter into a contract. But there is one interesting thing with respect to lunatics agreement. What they're trying to say is, let's say there is a person who is regularly of sound mind, but during full moon or half moon, during full moon, what happens is he turns insane on that day only. Now, if that is the case, the law says it's okay, it doesn't really matter. He is sane, no, for the rest of the time. During that time, if he enters into any contract, then it is valid. That's fine. Then at the same time, let's look at the reverse situation, wherein someone is sane only on one day in a month. Rest of the days he is not sane. Then the court says during the day where he is actually sane, if he enters into any contract, then it is valid. During the rest of the days, if he enters into contract when he is not of sane mind, then it is not valid. So that is what they say when it comes to lunatics agreement. Next. Of course, person disqualified from law, it is obvious. I won't get into that. Next. Free consent. We have already seen this briefly, but let us look at it with some depth. Free consent. Consent, permission, you can say. Free consent without being forced. Basically, this meaning, it's not the meaning of free, but here in this context, parties to the contract should come into the contract or should enter into the contract on their own. Their permission to enter should not be coerced or unduly influenced, or you do not exert any type of influence so that they are probably forced to enter into a contract, or you cannot misrepresent few facts to make them enter into a contract. You cannot cheat them to make them enter into a contract. If you do all of these, then we say that contract does not have one of the most important elements of section 10, which is free consent. If free consent is absent in the contract, it is not a contract at all. Okay. Anyway, let's see. Okay, again they say the same thing. If when this consent is wanting, that means it is not there. If it is not there, we want it. So when this consent is wanting, the contract may turn out to be void or voidable. Again, the party whose consent is not free can make the contract voidable. Okay, or for him it is voidable, he can make the contract void. Next, willful representation or fraud. This is again part of free consent. Let's see what exactly they mean by this. Fraud means and includes any of the following acts committed by a party. Which are those acts? The suggestion, okay, as a fact of that which is not true. A is telling B, I have a horse which runs at 50 kilometers per hour. Suggestion as a fact, which is not true. The horse only runs 25 kilometers, that particular horse. But still, he says it runs at 50 kilometers. Does he believe it to be true? Of course not. He knows the fact. And who does not believe it to be true? He knows that he is lying, basically. The active concealment of a fact by one having knowledge or belief of the fact. This is slightly different. Now, A is ready to sell his horse to B. B inspects the horse. I mean, he looks at the horse. It seems fine. But B asks, is there anything which you would like to tell me about the horse which might influence my decision to buy or not to buy this horse? Maybe does it suffer from any disease? Does it have like any periodical or seasonal ailments, etc.? No, A says no. But it isn't the case. A very well knows that this horse is suffering from, let's say, some kind of disease which makes it ill for half of the week. During that period, the horse cannot run or even get up. But B is inspecting this horse when it is hale and healthy. How will he even get to know that A is actually concealing or not telling all those things which he knows? This is nothing but active concealment, wherein you know but you conceal the facts. Okay. Next, a promise made without any intention of performing it. Cheating. A tells B saying, you pay me 50,000, I will sell my scooter to you. B actually makes the payment in advance, trusting A. But A had no intention of performing his part of the promise, that is to sell the scooter. He only wanted the money from B, that's all. Cheating, fraud. Any other act fitted to deceive, you are basically cheating. Any such act or omission, the law specifically declares as fraudulent. Okay, that's obvious. Now, again, the same thing is repeated. Let's not go there. Okay, let's quickly go through this. Actually, it's okay. Slightly important. The chief ingredients of a fraud are a false representation or assertion, this we have seen. A fact and not a mere opinion, this is also important, we have seen. Made with the intention that it should be acted upon, this is very important. Made with the intention that it should be acted upon. What they're trying to say is, you will do this act of fraud or conceal, whatever you do. Why? So that the other party acts upon it. B asks A, is your horse fine? Of course it is, says A. But is it? Of course not. So why did he do so? He wanted B to purchase the horse. Act upon A's willful misstatement, which is the horse is fine. Concealment, basically. The representation must have actually induced the other party to enter into a contract. B heard, okay, I have seen the horse, it looks fine, no issues from the outside, but he doesn't know that half of the week it will be sick. But A did so. A actually told B it is fine. Why? Because he wanted B to purchase the house. Now, listening to this particular statement only, B bought the house. So therefore, he has been induced to buy the horse. The party deceived must thereby be indemnified, for there is no fraud without damages. So you should also make sure that their damages are covered. That's okay. Statement must have been made either with the knowledge that it was false or without belief in its truth. You know it to be false. You know it is not certainly proven true, but still you make this statement so that the other party is influenced. So therefore it is fraud. Next, contracts of uberame fide, utmost faith. Let's see. There are contracts in which the law imposes special duty to act with utmost good faith. Okay. To disclose all material information. 1 second. Let me just... I don't know why they have inserted here. This has got nothing to do with free consent. This is how you prepare textbook, is it? ICSI. Anyway. Okay, what they're trying to do is they're trying to include this under fraud. Okay, fine. No issues. What they're trying to say is, in case of contracts wherein faith is assumed, like I believe whatever you say is true. That is the nature of this contract. If you say that you have this, you have this. If you say that you don't have it with you, a particular item, you don't have that. If you say that you know how to do this, I'll assume that you know how to do this. So now, in certain cases, you will have to disclose certain information, even though it is not asked. When you fail to disclose such information, then the contract actually becomes voidable at the option of other party. For example, contracts of insurance. The assured, that is you, the person who has taken up the policy is the assured, and the person who is giving the policy is the assurer, must disclose to the insurer all material facts, and whatever he states must be correct and truthful. Let's say you are getting your building insured, okay, because of you expect fire to be there because you are dealing with inflammable, highly inflammable items, so you are worried about the safety of your building. But you don't tell the insurer that you are actually working with highly inflammable items. If you are told that to him, probably he wouldn't have given you a policy, or maybe he would have charged a higher premium, because the likelihood of accident happening there is far more higher than in any other place where there are no inflammable items. So therefore, since you did not disclose an important fact which would have definitely influenced the other party to either enter into a contract or not enter into a contract, this contract will be considered as null and void, because there was no utmost good faith concept here. Next, company prospectus. When a company invites public to subscribe for its shares, it is under statutory obligation to disclose truthfully the various matters set out in Companies Act. Whatever has been mentioned in the Company Act saying that you should disclose all these points to your prospective investors, the company should disclose that in its prospectus. If it doesn't do, then it has violated the principle of utmost good faith. Contract for sale of land. The vendor is under a duty to the purchaser to show the good title to the land he has contract to sell. Okay, he should have a good title, meaning you cannot sell something which is not yours. If you do that, then again it won't be considered as a contract. Contracts of family arrangement, where the members of family make arrangements for settlement of family property. Each member of the family must make full disclosure of every material fact within his knowledge. That means, let's say there is a patriarch, the head of the family A. Now he is distributing his wealth or his forefathers' wealth to all of his children. So now when he is doing so, he should make sure that everyone knows what exactly the other party is also getting. So, or whatever the property is being disposed of, what is its value, etc. They should know. If you do not tell them the material facts, then again contract can be considered as null and void. Let's move on to the other element which violates free consent. We have already seen this, but let's look at it again. Coercion. That means if someone keeps a gun, points a gun at you and tells you to sign the contract, would you not sign? Obviously yes. That force or threatening to do something or threatening to cause physical harm is nothing but coercion. Let's read the definition. That would be far more interesting. The committing or threatening to commit. You either commit or you threaten to commit. If you don't do this, I will kill you. If you don't sign this contract, I will definitely injure you. If you don't sign this contract, I will cause harm to your daughter or son. Okay. So committing or threatening to commit any act forbidden by the Indian Penal Code. Okay. Or unlawful detaining, kidnap, or threatening to detain, threaten to kidnap any property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. I want to sign this contract, or let's say A tells that he wants B to sign the contract, but B is not ready for some reason. Now what does A do? He tells B, if you don't sign this contract, I will make sure that I will cause harm to your daughter who is studying in some class. I know where she studies. Now A is threatening to kidnap B's daughter. So when you are threatening to detain with an intention of causing some harm to B so that he enters into an agreement. So this is a classic case of coercion. Okay. Okay, there is one important point here. Let's look at that and then move on. It has been held that mere threat by one person to another to prosecute him does not amount to coercion. I'll file a case against you if you don't do this. Not coercion. You can say such things, but it will not be considered as coercion, of course. Undue influence, another important element which violates free consent. What is this undue influence? Now, in case of undue influence, what happens here is you are not threatening anyone. You are using your power to dominate the will of the other. That's all. So how will you be able to dominate the will of the other? If you are in a fiduciary position, meaning, let's say you are a godman or some spiritual guru. You are a spiritual guru who has a particular devotee, and that devotee listens to whatever you say. So now you are in a dominant position. because the devotee is fully devoted to you. Whatever you say, that person will do. Now, can you ask that devotee to sell their house to you for, let's say, for 1 rupee? Since consideration need not be adequate, we'll sell it for 1 rupee. You sell it for 1 rupee, I will pay you 1 rupee. That's what the spiritual guru told the devotee. The devotee was completely influenced by the guru. Whatever the guru said, he thought, yes, this is for the benefit of greater good. This is for greater good. Maybe it will benefit the world at large. So therefore, I will donate my property. Basically, it's donation. Now, that contract can actually be considered as voidable contract at the option of the person who donated that property, because here the person who bought the property has a dominant position over the other party, through which he obtained some unfair advantage. What was the unfair advantage here? To purchase the property at throwaway price. So therefore, in this case, we can say there is undue influence and therefore voidable at the option of the devotee. Of course, this is not the only example. You can also think of doctor and patient. If the patient is a terminal patient, he may die at any point of time. But this doctor who knows this patient has enough money, enough wealth, what he says, see, I don't know if you would want to try this, but there is one medicine which is in US. I have to import from there. It will cost me 10 lakhs or let's say 20 lakhs. I can try that particular medicine. If it works, then you will be cured. Doctor knows it, knows for a fact that there is no such medicine. Whatever he is getting from US, or maybe he is not getting anything from US, but still he goes ahead and promises this particular patient. If that is the case, you are again using your undue influence. You are using your dominant position to influence someone who is not in a dominant position for your advantage. Okay, so that is also an example of undue influence. Legality of object and lawful consideration we have already seen. I don't want to get into that. Let us look at few things with respect to illegal agreements. An illegal agreement is already void or entirely void. Whatever is illegal agreement cannot be considered as contract at all, because the word here illegal says that it cannot be enforced by law. No action can be brought by a party to an illegal agreement. We have seen smuggling agreement. Again, it's all repetition. I won't get into that. What exactly illegal agreement does, you can read it later on. Detailed explanations for all this is available in our website. Please do register. I'm just making this announcement once again. Here we are trying to cover the important aspects because we have less time. Whatever is not covered here in the live class is already covered in the recorded sessions. You may wonder, how do we get the recorded sessions? Very simple. Go to our website, register there, you will get it free of cost. Agreements being opposed to public policy. Again, this is a slippery slope. What is public policy now? Not defined anywhere. But let's see what exactly these are. The following agreements are void as being against public policy, but they are not illegal. Okay, let's see. Agreement in restraint of parental rights. So if someone says, I will give the custody of my child to someone, then it is not a valid agreement, or rather it is something which is against the public policy. Agreement in restraint of marriage. If someone says, I denounce, I won't marry this person, I won't marry that person, if they say, then that agreement has no legal standing. They can still go ahead and marry later on and no one can question, because such agreements can be against public policy. What? Restraint of marriage is public policy. So therefore, it is considered as void. Marriage brokerage, wherein A tells B, I will give you 20,000 rupees if you find a match to my son. Marriage brokerage also is void agreement. Such agreements is totally considered as null and void from the beginning. Void ab initio, that's what they say. Agreements in restraint of personal freedom are void. So if someone is trying to restrain your freedom, or someone tells you, you work for me, but you should stay in the office 24/7. You work for me, but you should make sure that you host everyone at your place after the office hours. Again, personal freedom is being restrained here in both the cases of the employee, therefore void. Agreement in restraint of trade. If you agree not to do something, not to sell your stuff, not to render your service to someone, then it is also void. So which are those void agreements? Agreement in restraint of parental rights, restraint of marriage, brokerage, personal freedom, and in restraint of trade. All these are void agreements. Wagering. Wagering is nothing but betting. Okay. So these are also declared to be void. For example, A and B enter into an agreement that if England's cricket team win the test match, A will pay B rupees 100, and if they lose, he will pay, that is, the other party will pay. Wagering. So if there is a wagering agreement, then the parties to the wagering agreement cannot sue the other parties even though they do not pay. That is the thing about wagering agreement. This is interesting. They say in India, except Mumbai, wagering agreements are void. In Mumbai, wagering agreements have been declared illegal by the Avoiding Wagers Act 1865. That means in one place it is illegal. Which place is that? Bombay or Mumbai. In rest of the places it is void. There are examples, you please read that later on. Okay, let us look at void agreements. Agreements by or with a minor. I already told you about this. Competent, incompetent. This is an incompetent person according to Contract Act. Person of unsound mind, incompetent, not someone who can enter into a contract, or person disqualified. Agreements made under a mistake of fact. Here again it comes under the free consent aspect actually. Both the parties to the contract, let's assume there are two parties, have mistakenly entered into contract. One thinks that A is selling his car, the other thinks that A is actually selling his scooter. Mistake of fact. So therefore it is not valid, it is void. Agreement of which consideration or object is unlawful. We have looked at it enough number of times, no need to go there again. If any part of a single consideration for one or more objects or any part of any of several consideration for a single object is unlawful, the agreement is void. Basically what they're trying is to say is 1, 2, 3, 4, 5. There are 5 different parts of the contract, and one of the parts or maybe one of the types of consideration or one of the consideration for different contracts is void or illegal. So in such a case, if one is unlawful, the entire agreement is void. We have already seen that. An agreement made without consideration, subject to 3 exceptions provided in section 25, that we have already seen. All these are repeated. Okay, again repeat. Contingent contract. This is interesting. Contingent contract is a contract to do or not to do something if, only if, some event collateral to, that is attached to that event or contract, does or does not happen. This is the most important part. We will enter into a contract, but based on that. If that event happens, then we will do. If not, then there is no contract. Let's see what example they have given. A contracts to sell B 10 bales of cotton for rupees 20,000. If and only if the ship by which they are coming returns safely. So A and B are traveling, let's say to India, and A tells B, if we reach safely to India, then I will sell my, what is it, cotton bale, how much? For rupees 20,000. Okay. This is a contingent contract. A tells B, this is a contingent contract, don't expect me to do this if we do not reach safely. If there is some accident and if we are troubled, then there is no question of this contract. That is what they say to each other. Why? Contingent contract is a contract which depends on happening or non-happening of a certain event. That's why they say does or does not happen. Okay. Next, quasi contracts. Quasi, not actually a contract, but still deemed to be a contract by law. Let's see what are these. Implies. Law implies, assumes that this is a quasi contract. A quasi contract rests on the equitable principle that a person shall not be allowed to enrich himself unjustly at the expense of another. Okay, now I will give you an example, which is the best example in this case. Finder of lost goods. If you are a founder of lost goods, that means you have found someone's iPhone, let's say. Now what should you do? You should, let's say in the college or school, wherever you are, you have found someone's iPhone lying around. It's the updated version, 1 terabyte 13 Pro Max. Now, what is your duty? Your duty is to make sure that it reaches some authority who is responsible for that place. If you are in college, you will give to the college principal saying, I found this in our class or somewhere else. I found this in the corridor, kept near the window, someone might have forgotten. Now what did you do? You made sure that you did not unjustly enrich yourself at the expense of someone else. If you had not done that, the other person would have suffered a loss. It would be unjust from the point of their view because they simply lost a very expensive phone. They need not have, but because you did not return or give it to someone who has authority over that place, the other person is unjustly suffering. You are getting unjustly rich. So that is not allowed. Discharge or termination of contracts. Let's see what exactly we have here. How do we discharge? How or when do we say the contract is terminated? That is what we study here. Let me just quickly go through what else is left, then we'll move further. Okay, discharge or termination of contracts. When do we say a contract has been discharged or fulfilled, or when do we say that contract is no longer active? So we have few explanations here. Discharge by impossibility or frustration. When we entered into this contract, it was possible to enter or rather fulfill the terms of the contract, but now we can't do that because of some reason. So then it is discharged. Earlier it was possible, now it is impossible, or due to some reason we are not able to fulfill. So then the contract is discharged, no longer needs to be performed. It could, that impossibility will be there at the time of entering into the contract, or the impossibility comes into picture later on. Both are fine. Breach of contract. When the promiser neither performs nor does he tender performance, the performance is defective, there is a breach of contract. Basically, one of the parties who is supposed to perform does not perform, or he says, or he doesn't communicate anything at all. When that is the case, it is a breach. Breach means someone who was supposed to do something did not do that. That contract has been breached. Someone will suffer now. Okay. Of course, they can sue for damages, etc. All those things are there. The breach of contract may be actual or anticipatory. You will guess, or this person will not perform, or he will tell you, I won't perform. What will you do? The date of the performance is, let's say, 30th of April. Today only I'm telling you, I will not perform this contract. You can do whatever you want to do. So this is anticipatory breach. Actual breach is on 30th, you get to know he's not doing anything. The other party was supposed to do something. Actual breach. Okay. Breach of contract may occur before the time for performance is due. Okay. This may happen where one of the parties definitely renounces the contract and shows his intention not to perform it, or does some act which makes performance impossible. That means you have done something which makes the contract impossible, or you have done something which shows that intention was not there in your part to perform at all. So it is considered as a breach of contract. You were supposed to do something, but you did not do that. Okay. Next. There are few examples given here. Case laws, you please go through that. I won't get into that. Now there is this thing called remedies for breach of a contract. What are the remedies which we have? Let's say you have suffered a breach. Someone who was supposed to perform their part of the contract did not perform the contract. You have already performed your part of the contract. Now, Are they not supposed to perform? They are supposed to. Now if they don't, if they cause the breach, then what to do? If they cause the breach, then there are few remedies. What are those? You rescind the contract and refuse further performance of the contract. Cancel it. Whatever you have done is gone, but don't do it again. Don't continue from your side. Sue for damages. Again, all these are independent stuff. Solutions. It doesn't mean that you should do only one of those. You can do all of those as well. Sue for damages means, I did this, you did not pay me, I suffered mental agony because you did not make the payment immediately, I need damages, or I want you to make the payment of damages to me. Sue for specific performance. They did not perform, no? Now make them perform. How to? Approach court of law asking for directions to that party, wherein the court will say, you please do this. Then they will have to do this. Otherwise, it will be considered as contempt of court. Sue for injunction to restrain the breach of a negative term. Let's say they are causing disrepute to your image by writing against you in their newspaper. Now you get a notice from court of law, wherein the court will restrain from doing something. So that is there. Sue on quantum merit. Whatever you have done, quantum merit means I have done so much, pay me to that extent. That is what quantum merit is roughly. Now let's move on to contract of indemnity and guarantee. And not much is there in this chapter. It will get over soon. So what I will do is I'll continue this in the next legal aptitude class. We'll stop here for now. Thank you for joining, guys. We'll meet again tomorrow. So but before we wind up, let me just quickly remind you, it's not just videos about lessons in our YouTube channel. Of course, we cover a lot of academic stuff. Most of it will be academic because that is what will help you. But we also believe that sometimes you need inspiration. You would want to hear from someone who has already gone through all this rigmarole of coaching, studying and preparing and actually appearing for the exams. Someone who's already a CA or CS. So for that, we have this show on our YouTube channel called The World of Company Secretaries. What Alok sir does is he interviews all these practicing or those who are already in employment but who have already completed company secretary course. So you get to hear from them, you get to hear what their experience is working for so many years and how did they manage to pass the course. So maybe that might inspire you to actually pass the exam as soon as possible. So please do check it out. The World of Company Secretaries. It is available on our channel. Maybe there is a separate playlist for that as well. Just check it out. Thank you. See you tomorrow once again at 7:30. Tomorrow we'll be doing logical reasoning. Thank you.